Good morning, everyone, and welcome to our program today. It's about the different types of trust, and we are here with Ed Zetlin, who is an elder law attorney, and he will be talking about the various types of trust. If you have a question, please use our chat, and we will get to your question as soon as we can. And I'm going to go ahead and turn it over to Ed. And if everybody could stay muted, that would be greatly appreciated. Thank you.
Thank you, Elizabeth, and good morning, everybody. Thanks for joining me. I guess we're all inside right now, but so thanks for taking time out for today. And I don't know if she's done it. Usually Elizabeth puts my contact information in the chat box if you ever need to get in touch with me. So, but in any event, I do elder law, I do estate planning, I do special needs planning in Falls Church. My office is located in Falls Church, and I do these every month. And this month we're going to talk about different kinds of trusts. So I'm going to start out by kind of telling you a little bit about what I'm going to do. I'm going to kind of take you through not every kinds of trust that exist, but some basic concepts about how to think about different trusts. And I'll make some distinctions between them. And then maybe later on, we'll go into a little bit more details. So to begin with, there are two main categories that I'll start out with. And the first one is a revocable trust versus an irrevocable trust. Okay, so that's one category we'll talk about. And then a second category will be a living trust versus what's called a testamentary trust. So, and though that's a second category. So that's how I really want to approach this, so that you have some basic distinctions about these basic kind of concepts. Although oftentimes when we talk about a revocable trust, we are in fact talking usually about a living trust. So the two, living trust and revocable, they're not mutually exclusive. They are oftentimes the same, but for clarity's sake, I'm going to be talking about a revocable trust versus an irrevocable trust, and a living trust versus a testamentary trust. But let's just make sure we all understand the concept of a trust, which is something that was invented by lawyers hundreds of years ago. Basically, a trust is where one person called the grantor, that's the person who's creating the trust. It's usually whose assets are making up the trust. So that person is the grantor. And they create a document prepared usually by the attorney called a trust, in which they appoint another person called the trustee, or has another name, the trustee, who manages the assets. You actually manage the assets that are in the trust. The trustee actually has legal title to the trust assets, but the trustee has special duties to a third character called the beneficiary. Okay, so the beneficiary who benefits from the trust. Okay, they're the one that would benefit, would get income or assets from the trust. The trustee's job is to manage the trust assets and carry out the instructions of the trust document. Oftentimes, the grantor, the trustee, and the beneficiary are the same person. They can be the same person. That's usually true, particularly when we talk about doing a revocable and living trust. But that's the general concept of a trust. So you just need to know those three different characters: the grantor, the creator of the trust, the trustee, the person who manages the trust, and the beneficiary, the person who benefits from the trust. And that's the basic concept. I wanted to talk about revocable versus irrevocable trust. So a revocable trust is just what you think it may be. It's a trust that can be revoked. Okay. So oftentimes I will have clients that they want to do a revocable trust for usually to avoid probate. In this day and age, it can be used for some tax planning, but unless you have such substantial assets, it's not, it doesn't necessarily have to be used by that. So what I think you have to know about a revocable trust is that it's really how the IRS sees it. The IRS doesn't see it as a separate entity from the grantor because it's revocable. So you, the grantor, create a revocable trust and you put assets in the trust. You put your house, you put your brokerage accounts, all that kind of stuff in the trust. But the IRS, if your brokerage account is earning income, the IRS just treats it as if there's no trust at all. It doesn't treat it any different of the income that you make than what happens now without a trust. So they just don't look at it. So it doesn't get its separate tax ID. Okay, and that's what really that's an important concept with regard to the revocable trust, because the IRS says, look, if they can revoke it, we're not going to see it as a special entity until at some point it becomes irrevocable. And of course, the difference between a revocable trust and an irrevocable trust, of course, is an irrevocable trust can't be irrevoked by the grantor. Okay, it can't be revoked, or theoretically it can't be revoked. Sometimes it can be if you go to court and there's special circumstances, but basically it can't be revoked. So if you created an irrevocable trust and you transferred assets into the irrevocable trust, then the IRS does consider that a taxable entity. That is, that trust is its own entity. It has to have a separate tax ID. So it would have a separate tax ID, or called an identification number, and it would be taxed through that number. That's really what makes it an irrevocable trust. So an irrevocable trust is going to be taxable. In fact, it has a separate tax rate than an individual's tax rate. It's got to have a separate tax ID. And as opposed to a revocable trust, which is not going to have a separate tax ID, the trust assets are just going to be identified by your own Social Security number. So it's not going to really make a difference. So that's the primary idea. That's the primary concept that I wanted to get across. The difference between a revocable and irrevocable trust. We'll talk about why some people do one versus the other in a few moments, but I just wanted to kind of talk about that. And we'll come back to that in a few moments. And so the other category is to talk about a living trust versus a testamentary trust. So a living trust is a trust that you create, the grantor creates while they're alive. They create it while they're alive. They create a living trust. They transfer assets into the trust. And Oftentimes, it's a revocable trust. We'll talk about how that works in a few moments. But you create it right now. So the grantor, you as the grantor, you create a living trust. You are also the trustee, so you manage the own assets in the trust. And then you have a beneficiary, which is also you. So any assets in the living trust are benefiting you, the grantor, while you're alive. And you have control over the trust assets as the trustee. Now, a testamentary trust is different because it's a trust that comes out of a will. So here you create a will, and it says, I leave everything to my spouse, but if my spouse predeceases me, then I want my assets to be held in trust for my children until they reach a certain age. And you would put that in a will, and you put that language in the will, which means that the trust comes out of the will. It doesn't get created until you're dead, and then the trust is created, usually through the probate system. Okay, so you'd go make somebody dies, the trustee would go to make an appointment with the probate office. The will would be probated. A trust comes out of the will. The trustee, the instructions in the trust is to manage those assets for my children until they reach a certain age, and then the trust can end. But in one, you created the trust while you're alive. In the other, you create the trust. The trust only comes into an existence upon your death. So those are categories, concepts that I just sort of wanted you to understand. Oftentimes, probably about 80% of the trusts I do are living revocable trusts. So a couple comes to me and they say, we've heard about doing a trust, and we want to know about it, and what's it good for, and why would I do it? And I explain pretty much what I've talked to you about the grantor and the trustee and the beneficiary. And they want to know about, well, what about taxes in the trust? Does the trust have taxes? And I explain no, because it's a revocable trust. Any assets you're going to put into the trust, it's going to be, according to the IRS, it's going to be taxed as if you hadn't done the trust at all. So you will put, for the most part, your bank account, your brokerage accounts into the trust. You actually transfer the assets into the trust. You transfer your house into the trust. And you, as the individual, manage the assets for yourself as the trustee. And you're the beneficiary. Then, so you and your spouse are the beneficiary. So then one spouse dies and the trust continues for the other living spouse. But then they die. At that point, the trust says where the assets go upon the last of the grantors to die. At that point, the trust becomes an irrevocable trust. The grantors have died. The only person that could revoke the trust or change the trust were the grantors. They're gone. Now the trust instructions say who's the next trustee and how the trust assets are to be used. Oftentimes, it might say, okay, if my children are below the age of 35, I want my trustee to manage the trust assets for them. But then at the age of 35, the trust can be closed and the trust can go to them. Or it might say, I'm leaving all of my assets in trust to my children, my two children. And they can either keep it in trust for themselves, or they could distribute out all the trusts for themselves. But in any event, the trust becomes, the trust assets then benefit the people that you've declared to benefit upon your death. So the trust could continue, or can have other instructions. But at that point, when you die, it becomes an irrevocable trust, okay? Because the grantors are gone. And it would have to get a separate tax ID and all that kind of stuff. So why do we do this? Why are we doing these trusts? Well, the primary motivation for doing the ordinary living revocable trust is to avoid probate. So you want to, people put their assets in the trust. You can't put your retirement accounts in the trust, but you can put your other non-retirement accounts, your bank accounts, your brokerage accounts. You could put property into the trust. You can put your house into the trust. Oftentimes it becomes valuable to do that if you have a house in one state, or if you have a number of houses and you have some property in another state. Well, instead of opening two probate estates in the different states, you can put both houses into your revocable trust, and then upon your death, you don't really have to probate any of that property. That is, you don't have to go to court to distribute the property. You've named a trustee to take over at that point, and they take over the trust assets and deal with the trust assets without any court supervision. So it has an attractiveness with regard to that. That's a large motivating factor. Sometimes people want to, for whatever particular reasons, they want to do irrevocable trusts. And that's actually when you do an irrevocable trust, you're really transferring, you're making a completed transfer to the trustee. So for instance, suppose you wanted to get it out of your estate. You didn't want it to be a part of your estate. You still wanted to have some control over it, but you didn't want it to be part of your estate. You were maybe concerned about possible creditors or liabilities in the future, or other things. So you would create an irrevocable trust, put assets in the irrevocable trust. You still, in certain circumstances, could be the trustee, but it's not part of your estate anymore. If someone were to sue you and it's a separate irrevocable trust, it's not going to be attachable because you don't own the assets. The assets are owned by the trustee, and that trustee has beneficiaries. Usually you're not going to be the beneficiary. It might be other people, your other children. So often you see people do that who are concerned about possible creditors, people who say, look, I have a law practice or a medical practice, and I want to make sure that my children absolutely get some of my assets, but I just want to make sure in case I'm sued, this can't be attachable, so I'll create an irrevocable trust and get these particular assets in the trust out of my estate, so that and the trust can say, when I die, other people get these assets. We also use irrevocable trusts sometimes for Medicaid planning. So a person comes to me and says, I want to make sure that my house goes to my children, and I don't want to, if I ever need Medicaid for long-term care, I don't want that to be considered part of my estate, and I have to spend that money down. So I would like at this point to create an irrevocable trust I want to put my house in the irrevocable trust. And after 5 years, if I need Medicaid long-term care, the state of Virginia can't look at that asset because you've transferred it out of your estate. It's owned by the trust. You don't own it any longer. And in that way, you protect it with regard to Medicaid. So that's a very special reason. I, as an elder law attorney, probably do more of those than other attorneys, but that could be a reason why you are doing an irrevocable trust. Why do we sometimes do testamentary trust? Well, suppose I have a young couple and they have a new child and they have life insurance. They don't have a whole lot of assets. They're not really worried about probate that much. They don't have a whole lot of assets, but they have life insurance, and they might have house. They don't, at this point, they're not ready to create a living trust. They would simply like to have a will, and the will would say, when I die, if I die and I have an assets, and my spouse is predeceased, then I would like to have named this trustee to manage these assets that would come out of my will. So it's a simpler trust. It's easier to do. It probably will never come into existence because the trust probably says, well, if my children are 22, all of my assets are left straight out to my children. So we often do testamentary trust when we're concerned about minor children, and we want to have some protection for the minor children, but we don't want to go to the trouble of creating a living trust. So we might just do a testamentary trust that comes out of your will. And that's kind of often where that comes up. So let me see where we are time-wise. We're about at 11:21. I am now going to talk about a few other specific trusts, things that you may have heard about a little bit. I don't want to go into trusts that deal very much with federal estate tax planning. There are trusts you can do if you think you have a estate, if you think you're going to have an estate tax. But you have to have over $12 million to worry about that, at least for right now. So I don't know how many of you have $12 million. If you do, give me a call. I'll help you do some important tax planning. But most of us don't have quite that much assets. So I'm not going to get into all those fancy trusts that attorneys use for doing that, although I'm sure that will come up later on, and so we can, I might touch upon that. Sometimes we do trusts involving a second marriage, where one spouse says, look, I have children, I'm married now, this is my second marriage, I have children from my first marriage, I want most of my assets to be left and to go to my children from the first marriage. On the other hand, if I die before my current wife, I want her to have some benefit from my assets. So we do trust that can do that kind of planning. So where you, if you die, you say, I'm leaving my assets in trust. I want my surviving spouse to have an income benefit from the trust assets, and for certain special reasons may be able to attach principal. But then when he or she dies, I want those remaining assets to go to my children. Oftentimes we call those a Q-tip or a trust with a terminal. It's a trust that can be used and in certain cases, both spouses may have a Q-tip trust because they both might be coming into it with children from a former marriage. They want each spouse to benefit from each other's trust, but they want to make sure that those assets in those trusts, the remaining assets, when the spouse dies, goes to their children. So that's a special kind of trust that attorneys can do in those certain situations where you want to benefit a particular individual, but that you want while they're living, but then you want the trust assets to go to other individuals when that person dies. So that's another kind of trust that you can do. Now, kind of trust that I often do when I'm dealing with special needs children, and I have clients that have special needs children, is I will do a special needs trust. So this is a trust. It's a trust that's created. It's a living trust, so it's created while the parents are alive. The trust, however, is going to hold assets for their special needs child. Usually when both parents have died, they're going to have a will that says we leave part of our assets into this special needs trust. It's an irrevocable trust when they die. The trust, the beneficiary, who is the special needs child, they're never going to be the trustee. First of all, they're incapacitated, so they can't be the trustee. And so the trustee will manage those assets for the benefit of that special needs child, but the public benefits that that child is getting, Medicaid, SSI, they can't be counted by the state as available to them. So we will use those trust assets to protect that child throughout their remaining lifetime, at the same time not affect their public benefits. So that's kind of something I do because I do a special needs law and I have a Medicaid background, so I do a fair amount of special needs trust, which, you know, the parents create now. They could revoke it. It's a living trust. It becomes irrevocable upon their death, and assets would go into the trust upon their death, and those assets would benefit their special needs child for the remaining lifetime. So that's a special needs trust. I am ready now to begin to take some questions. We have a lot of time left. We have about 30 minutes left. So I am ready if you have some questions. I guess there's no questions in the chat box. So if there's not,
Not currently. Yeah.
Not currently. Okay. So
if you have a question, go ahead and chat and put it in the chat and we can address it.
No questions at all? Okay. All right. So can you read that for me, Elizabeth?
Sure can. Will the surviving spouse of a joint revocable living trust pay higher taxes on the income generated by the investments in that trust? In your experience, has this been a problem for high income couples?
Okay. So you're talking about a joint living trust, right? Joint living trust.
Correct. Revocable.
Revocable. Remember what I said. The assets in that trust, it's like you don't have a special tax ID. The assets in that trust, whatever earnings, is going to be treated as if there's no trust at all for the IRS. So it's going to have absolutely no impact upon your income tax. you're going to do an income tax for the assets that were earned in the trust, just as if there was no trust. So there's no impact. Okay, that's the main concept I wanted to get across to you. Okay, there would be no difference if you have a joint revocable trust and one spouse dies, the trust continues for that spouse. Okay, but it still doesn't have a separate tax ID. The income from the trust will simply be taxed to the surviving spouse as if there was no trust. So it has no impact. Okay. So can you read the second question?
So it says, what about after the death of a second spouse?
Okay. So then after the death of the second spouse, we look to see, what does the trust say? What is it? Does the trust at that point say, all my assets go to these people? Well, that's the end of the trustee. The trustee who takes over at that point would simply distribute out all of the assets to those particular people. Okay. Now, it might not say that. It might say that I have a child who I think is a spendthrift, and I want to maintain these assets with the trustee having some discretion as to how they make distributions. But I don't want that child's debts to be attachable to these assets. And yes, at that point, the trust will have a separate tax ID, and it will be taxed. Usually, trusts are taxed at a compressed rate. They're taxed at a compressed rate. That is, at $600 of income, after you earn $601, that $1 becomes taxable income. Okay, so let's suppose this is what you've done. You've created a trust. When you both die, you've created this other trust that's for a child that you're worried that they're debtors. On the other hand, you want to make sure that there's some assets for them. Well, during that time, the trustee may make distributions from the trust. They might pay for, at their discretion, they might pay for health issues for that particular child, or they may buy this child something else. Distributions from that trust, although it's taxed at a greater rate, distributions, particularly income, lower the taxable amount, because you've taken money out of the trust and that reduces the taxes on it. So oftentimes, not always, but oftentimes, because we're making distributions from the trust, we may not have any taxes that year because we've made some distributions. So we're protecting the principal, but we're distributing income. And you can even say that I want income distributed to my child, but I don't want principal attached. So if you distribute all the income, even though it's taxed at a higher rate, there's not going to be any tax owed because you've distributed all the income. Okay? So that's something to keep in mind. On the other hand, if the income accumulates, yes, it's going to have a higher tax.
Okay, so the next question is, if your assets are under 2 million, most in retirement accounts, any benefits to creating a trust?
If your assets are under 2
million, most in retirement account, any benefit to creating a trust?
Well, okay. Let me go back and talk about retirement accounts. That's a special kind category. So you have IRAs, you have 401ks, you might have a 403, you have different kinds of retirement accounts, okay, while you're alive. You can't really put those retirement accounts into the trust, okay? If the only way you could do that was be to pay the taxes to the IRS, pull out all the money from the account, pay the taxes, and then put that money in the trust, which is, sometimes that can be done, but oftentimes we're not going to do that because, we've used the retirement account to build up increased assets because they haven't been taxed. Those don't usually go through probate anyway. Why? Because they go by beneficiary designations. So you've designated your spouse as the beneficiary, and then you've designated your adult children as the beneficiary. So oftentimes we don't, if we may not want to, we're not going to put those assets into the trust at all. So it could be that if all the assets are retirement accounts, there may not be any benefit for having a trust because we're not worried about probate because all the assets are simply going to go by designated beneficiary. So it may be, we may decide, well, we just might do simple wills just in case there's something that's not a retirement account. But otherwise, we're simply going to leave assets directly to the beneficiaries. Now, that's the best answer. I'm hoping I'm getting to your question there. In any event, there's no right or wrong action. You might have assets under 2 million, but you might decide, part of my assets would have to be probated, so I want to avoid that, so I'm going to create a living trust. So there's no set one rule. Everybody, when you go see an attorney to do a trust, you have to show you need to declare what your assets are. So then we could figure out what it is, what are you concerned about? What do you want to do? And then the attorney can advise, well, what's the best way for this work to meet your goals? So the first thing is, what are your goals? What do you want to do? What is it? Are you concerned about probate? Maybe you're not. Maybe that's not a big deal for you. And you think, well, let the probate system work its way. And that's the way it's going to be. And that's fine. That's okay. It really depends upon what the client wants.
Okay, so the next question is, I have a revocable living trust. How do I transfer assets into the trust?
Okay, so you go, if you have a house, the attorney will do a deed and we will transfer your house that you're living in into the trust by a simple deed. So you as the owner, I as Ed Zetlin, I deed my house to the Ed Zetlin Living Trust. Ed Zetlin is the trustee. That's how I do it. I do a deed. For bank accounts, you go to the bank, you show them the certificate of trust, or you show them the trust. You say, I want to move my bank accounts into this trust. They do it. They open up, they move your accounts that are simply in your name into the name of the trust. That's it. If you have a brokerage account, you go to your brokerage person, you say, I've created a trust. I want to move my brokerage assets that you're investing for me. I want to put them under the name of the trust. They do that. That's how you do it. Okay. Next question.
Okay. Once a revocable living trust is created, how do subsequent assets get included? I think you just talked about that.
You just put them in there. You just go to the entity. You say, I've created a trust. Put these. I want you to transfer these assets under the name of the trust. That's what you do.
Okay. Next question. a trust designates my children as the 50-50 beneficiaries of my home. What tax considerations will they have with the IRS if one of them decides to live in the home and one receives rental income from the property?
Well, there
So it
are,
sounds like the home is left to both children, but one wants to live in it and the other one would get, I guess, rent from them or.
well, I don't want to get in too much because I have to look at, I mean, you're already getting to too many details for me to advise you about what's the impact. A trust that you leave to your children, your house and your trust that you leave, that when you die, it goes to your children. There's no real tax consequences, okay? They get what's called a stepped up in basis. So the value of the house will be the same. If they later go to sell the house, the value of the house would be what the value of the house was when they inherited it. Okay. So in that sense, there's no tax consequences. Just like if you have an asset and you leave, let's suppose you have a house and you say, I leave my house to my child under my will. You bought the house 30 years ago for $170,000, and now the house is worth $800,000. The child inherits the house when you die under the will. Okay. Suppose that child later wants to sell that house. Well, there is something called capital gains, which is the amount, the difference between the value of the house that you sold as opposed to when you acquired. Well, if there wasn't a stepped up basis, the difference between $800,000 and $170,000. But when you die, that child gets a stepped up in basis. So if you die and the house is now owned worth $800,000, their basis is not 170, their basis is 800,000. Now they may hold the house for many more years and it may go up in value, so there'll be there could be a taxable event then, but essentially there is no taxes that you need to worry about. Okay. As for these other issues in your, I would really need to see what you. Obviously, if a person is getting rent, if you're getting rental income, that's taxable income. Okay, rental income is taxable income, and that just gets thrown into your income taxes along with everything else. Okay.
Okay. One question: who manages a special needs trust for the disabled child?
That's a very good question. So, who would be the special needs trustee? Well, you're going to name, if you do a special needs trust, you're going to name a trustee. Okay, you're going to name and say, upon my death, this is who the trustee is going to be. So you have to decide. That's one of the big issues, is who's going to be the surviving trustee and really manage those trust assets for the lifetime of that special needs child. You would appoint somebody in the trust when you set it up. Okay. And part of when I talk to people about doing special needs trusts, we talk about who could be the trustee. Okay. That's what we talk about. It could be an individual. It could be a relative of the child. It could be, if there's enough assets, it could be a trust company that understands special needs trusts. But that's something that has to have some discussion. Next question. We have a next question.
Good.
I see that. Yes, I always take new clients, but I don't talk about rates.
And I'm sending her a chat. I will send out the information to her. If
Okay.
anybody would like Ed Zetlin's information, please contact me and I'll be happy to send it. We have another question.
Yeah,
After
here's
there are consequences to renaming assets under the revocable living trust, accounts are no longer in the grantor's name, which may be required for things like proof of residency at the DMV. Not sure.
I'm not sure if I understand the question. I'm sorry. I'm not sure if I understand that question.
So talking about renaming assets under the revocable trust. So I guess like a car.
Yeah, I generally don't put cars in the trust. You don't rename assets. The trust owns the assets. Yes, the brokerage account is owned by the trust. A car, I don't generally put cars in trust. So I would leave your car in your name. Sometimes we put other items, boats and things in the trust. But I don't usually generally put cars in. I don't recommend. You're right. It's too much of a problem for the DMV.
Okay. How to protect assets from a spendthrift child?
Well, I kind of talked about that before. So, so you create a living trust. Okay, trust benefits you and your spouse throughout your lifetime. Okay. Then, when you die, in that trust, you say, you have a trust, and then you die. Out of that trust comes another trust for your child. Okay. That's the instructions. You've named a trustee. Okay. Not that child. And the trust is going to say, these assets in this trust, although the trust is to be used for the health and maintenance of my child, the trust assets shall not be subject to the creditors of this child. Okay. That's called a spendthrift trust, which means if that child runs up debts, that creditor can't go after that trust. That's what that means. So the assets are used to help the child, but it's not going to be subject to the child's creditors because we put that magic language in the trust. Remember, the child doesn't get the assets in their name. It's your assets. It's not the child's assets. It's the trust assets. It's your assets originally. They never earned those assets. You want to benefit the child, but those assets never went directly to that child. They're always held in trust. So creditors that a child might have can't seize those trust assets. That's how that works.
Okay, so the question about the car, if a car is worth $50,000 and it's not in the trust, then what would that require the estate to go through probate?
No, because the DMV has its own way. Usually what you want to do is you can say in your, nobody probates a car. I guess you could say if you want to sell the car. Generally, and the car's worth $50,000. But generally, what I would do is I would have a successor in interest to the car with the DMV. That's what I would do. I would say this car is going to go to this other person upon my death, which you can actually put in the title. mean, you could put it into the trust. Yes, you could put it into the trust. I'm not saying you can't. And if you would, what you wanted to do is you wanted the trustee to sell the car, you could do that. Yes, you could do that if that's what you wanted to do. Okay.
Okay, one more question. Any problem with using a transfer on death deed instead of putting your home into a revocable living trust?
Okay. So no, we have a statute in Virginia. Now, we didn't always have this statute, but some years ago we created a statute that said you could create a deed that says upon your death, this house goes to some other person. Now, that can work, and it avoids probate. That can work. So it can be a way of avoiding probate, because upon your death, that deed already says who owns the house. So what has to be filed is a death certificate showing that you're dead, but then that other person, the deed's going to say who owns that house. So, you know, that is a way of avoiding probate. Although it's even I'm not going to get it. Virginia treats how real estate different than other states, because technically, if you die and you have a house, that house drops down to your heirs at law. So they immediately own that house. And you don't even have to file probate. The only way, I didn't want to, someday I'll do a lecture about real estate in Virginia and how real estate passes in Virginia. This is probably not the lecture to do that because I'm just going to confuse. But yes, you could do a deed that upon your death, the deed says it goes to my child or this child, and nothing has to be done except that you have to file a death certificate. Okay.
Okay, so someone's asking, can you talk about trust companies, pros versus cons?
So there are companies that are happy to be your trustee and to manage the trust assets. Usually, any trust company I've noticed is going to say, but we don't want to do it unless there's at least $1 million in the trust. So if we know there's $1 million that's going to be in the trust, that can work. Okay. One of the good things about a trust company is they know what they're doing, and they're going to be there. Usually, they're going to be there. Whereas if you name an individual, they may not be there when the time comes. So sometimes it's prudent to name a trust company, or you might name a individual, but if you say if this individual is not there, then I want this trust company to take over and manage the trust. That's perfectly fine. You should see what their rate is. They don't do it for free. There is a rate, there is a charge, so you have to know what that is. Those rates could go up. And again, they're not going to want to do it unless there's about $1 million, because their fees are based upon their managing the trust assets. So, if you have an individual, then sometimes, the individual may know the person that you want to benefit better, and you may want to do it that way. You may want to have somebody there who will be able to actually deal with some of the personal issues that come up, Some attorneys will be the trustees, and then I can act as a fiduciary, although I'm usually not doing it unless clients are older than me, because I'm getting older myself. So again, those attorneys will get a fee. Some people like them because there's an actual person, they know the person, they trust the person, and they're happy to do it that way, as opposed to an anonymous trust company. Okay, but they both have their place.
Okay, so it looks like one more question. Why avoid probate? Is it because of less taxes?
That's a good question. There's nothing inherently bad about probate. Okay, it's not about taxes. It is, if you have to probate an estate, then the court is going to oversee the payment of debts and the distribution of money. So there's work to do in Virginia. You have to file an inventory, you have to file accountings, and you have to show to the court, to the penny, everything that's done. And it can take some time. So, it's taking me, it's taking me, I mean, the first accounting is not due until a year after the date of death, or a year after you've opened up the estate. So, and in fact, you're not even going to make distributions until 6 months go by. So it takes longer. It's more time consuming. And depending on how complex it is, there's work to be done, because you've got to show to the court how you've spent every penny and where every penny has gone. And so that takes time. Often people, they mess things up, and they need professionals to do that. So there's some cost involved with that. On the other hand, the court oversees everything. In a trust, there's no trust police. Nobody oversees the trust. When you do probate, the court's going to oversee everything and is going to make sure that the will is carried out according to the directions of the will. They want to make sure that the money goes to the people that says in the will the money goes to. So in that sense, there's some protections with regard to probate. That was the idea. Okay. So there are, there's no absolute badness with regard to a probate. Okay. So I hope that helps a little bit.
So that wraps up our questions, and that was perfect timing. If you want Ed's information, please contact me and I'll be happy to forward it to you. Thanks, Ed. This was great information and lots of opportunities for people to get questions. If you'd like to join us next month, we will be having, oh gosh, wait a minute.
I'm not doing it in August.
That's right. August, we're not doing it. It'll be September, October, and November. So look in your guide for details about the topics that Ed will cover. Thanks, everybody, and have a great day.
Yep. Thank you.